PI show, and we're talking about victims of crime assistance legislation with Gary Nicholson, Harry Nowicki. We're on the topic of victims of crime, Gary, and we're talking about the various categories of people that can claim.
Yep.
But how do you claim? What's the procedure?
Procedure's fairly simple. There's an application form that needs to be completed, setting out the details of the applicant, details of the crime, details of the police reporting, and listing your injuries in a very simple form. That application then lodges with the Magistrates Court. They acknowledge the application and then ask you to file further material. So you build on your case after having made your application.
What do you reckon you'd file, Harry?
Well, you need medical material, but does the criminal get notified that there's an application?
No, only in limited cases does the criminal get notified. If criminal charges are laid against the offender and there's a conviction, then there's absolutely no need at all to notify the offender. If the offender's not charged or charged and acquitted, either in Magistrates Court or at trial, the tribunal has a discretion in which to notify the offender that an application's been lodged. The offender can then make up his mind as to whether or not he wants to get involved in the application. He can choose to ignore attending the court, and there's no repercussions on him.
So it'd be the offender would be in effect foolish to attend the court. In
most cases, I would think that offenders would take legal advice and be told, well, you've been acquitted of the crime, so why do you want to go back and put yourself in the witness box again for a second grilling?
What's a good example is a rape case, I'd imagine, Gary.
That's probably one of the most common situations. Yeah, sexual assault case and rape cases where there is an acquittal. Offenders are notified that an application's been lodged, but in most cases my experience has been that they don't respond or simply don't want to turn up.
So in those cases, the evidence before a magistrate would be the victim, if you like, and he or she might say, well, look, this is what happened to me, and the magistrate would accept that evidence.
Yeah, well, the standard of proof in a victims of crime matter is, of course, lower than in a criminal matter. In a criminal matter, the police have to prove beyond reasonable doubt that the offence has occurred. But in victims of crime, the hurdles reduce somewhat to the balance of probabilities as in a common law negligence case.
And in some circumstances, you wouldn't report anything to the police.
The general rule is that the crime must be reported to the police. The legislation really works on a two-way basis. That is that the government will provide assistance on the basis that the victims report the crimes to the police so that they can be prosecuted, and that benefits both sides. But in limited cases, people are unwilling to report to the police. May be a long history of violence from the offender, and they may feel that it's just too dangerous for them to report to the police. And in those cases, a magistrate has a discretion after hearing all of the evidence as to why you didn't report. And if you're able to substantiate those reasons and still provide evidence that there has been a crime.
Is there time limits, Gary? I mean, do you have to lodge it within a certain time?
Yeah,
or do you have to report it within a certain
there are time limits. The tribunal's rule is that you must make your application within 2 years. In the event that you don't make your application within 2 years of the happening of the crime, you can apply for an extension of time. There's rules in relation to extension of time, and the court takes into account such as the age at the time of the offence, so that if you were an 11-year-old child sexually abused, you wouldn't necessarily be in a position to go and report the matter.
It's pretty flexible.
It's very flexible.
And Gary, just getting back to benefits that are available, we understand there's a cash component of up to $10,000.
Up to $10,000 for primary victims.
Primary victims.
And the balance of the package is up to $60,000.
And that's loss of income?
Loss of income to a maximum.
And is that a matter of evidence about...
A matter of evidence, so that if you're a wage earner and you've been off work for, say, 10 weeks, the tribunal would ask you to produce a letter from your employer saying that you earn $600 a week, a medical certificate to say you've been away for 10 weeks, and you'd receive your $6,000 loss of earnings.
What about death cases? What's the entitlement there?
Okay, the death cases is, again, a different amount of compensation. The assistance is a $100,000 package to the family of the related victim. The $100,000 is divided between the family members who apply. So
What's
obviously,
this package, Gary? Is
It's a cash
monetary?
component.
cash
Component.
compensation,
What, a whole amount?
Yeah.
a whole amount. yeah.
Okay.
So in a situation where there's been a murder and say the surviving wife and 3 children apply, they can potentially take out $100,000. It may be $25,000 each. It may be in some other
Is the whole
combination.
100,000 paid out, or is there?
In most cases, the 100,000 maximum is paid out. The tribunal also has a discretion to go above 100,000 in exceptional circumstances, and that could be where perhaps it's a very large family of say 14 or 15 applying. Tribunal might increase it slightly to 125 or 130,000.
Well, getting back to that Carl Williams case, does the ex-wife or daughter have an entitlement there? Or
Well,
anyone
clearly,
else?
looking at the
Father?
legislation, she has a prima facie case to apply, and that's not special to her. That's been all of the gangland-related murders have seen applications.
Has she approached you yet?
She has not approached me, no. But
After watching the show, she probably will.
so yeah, the family would be entitled to apply. The legislation does have provision where they can take into account the past criminal activity, if any, of the deceased in those situations.
And would it reduce the amount?
Yes, the magistrate has a discretion. He can completely refuse or he can apply a reduction. He might say, look, I'm going to pay out, but I'm going to reduce it by 50% because of the past
criminal-
history.
So the character of the victim comes into play as well.
The character of the victim doesn't so much come into play, but the court can take into account the victim's prior criminal history.
So that's really applying community standards, because a lot of people would be outraged that the Carl Williams family can actually get some compensation, given the whole gangland history.
That gangland history has seen applications that have been lodged, and people
Have
have
they
said
been successful?
many have been successful. And I mean, I guess in many ways, why should you punish the surviving family who may have not had any control over the activities of the person who's now deceased?
And what about funeral expenses? Do they cover that?
Funeral expenses are also paid in a related victim claim, and that payment can be made in addition to the 100,000.
Gary, look, we're getting towards the end of...
Just one other question I've got, which is I think quite surprising, is the number of actual claims made in Victoria each year.
Extremely low. Around 4,000 claims a year are made, which is a very small number in comparison to the amount of crimes, both reported and unreported crimes in Victoria.
Gary, we're running out of time, so look, I'd just like to thank Gary Nicholson for appearing on the show tonight. It's been very insightful there.
Very
Gary.
informative.
And I'd like to thank you for having me along tonight.
And he's Victoria's leading specialist in victims of crime.
And we're going to a sponsors break, and after the break we've got Viv's mailbag. So keep watching.
Thank you.